this book has been a work in progress for a very long time. And when I say a very long time, I mean that. As a matter of fact, the work spans over 3 different decades, during which I have worked at 2 remarkable institutions, the Erik Castrén Institute and the Finnish Institute of International Affairs. And many people have been involved in this process and helped me in so many different ways. I know that there are former and present colleagues from many parts of the world in the audience today, which makes me happy. I'm also immensely grateful for having this opportunity to discuss my book with Professor Koskenniemi and Councillor Tarja Långström. Thank you both of you for taking the time to do this. I also want to thank Professor Koskenniemi for helping me during the long path of turning what was my doctoral dissertation into the book, and also for writing the foreword. I'm also grateful to Professor Klabbers for his support, and commissioning editor Tom Randall at Cambridge University Press also deserves mentioning. Naturally, FIA's old and current leadership has supported my book project as well, so thank you, Mika, for that. And to the audience, let me also say that there should be in the chat, at least after a while, a promotional flyer with a discount code to be used if and when you decide to purchase my book. So in my contribution here today, I will try to answer some basic questions about my book, such as why I wrote the book in the first place, what my approach is, and the argument, as well as how it contributes to international legal scholarship. To start with, let me briefly mention what state responsibility law is about, as I know that there are in the audience people who are not international lawyers. So state responsibility refers to the rules that become applicable when a breach of international law has taken place. It pertains to retrospective responsibility and how other states may respond to these internationally wrongful acts, as they are called. So state responsibility covers situations such as Russia's violation of Ukraine's territorial integrity in 2015, but it also covers more mundane situations when a state, for example, fails to inform another state of having arrested its national, so that consular assistance is precluded. The state responsibility rules lay down what constitutes an internationally wrongful act, who can react to the breach and in what ways, what the invocation of responsibility aims to do, and how responsibility can be implemented. These general rules are customary in nature, so there is no treaty on state responsibility. And these rules are codified, however, in a set of draft articles finalized by the International Law Commission in 2001, after almost 50 years of work. Next to these general rules, states are free to decide upon special rules if they want to. The inspiration behind the book, that is why I chose this topic, stems back to 2003-2004, when the world was appalled by the abuses occurring in the Abu Ghraib prison in Iraq. US soldiers and private contractors had repeatedly abused prisoners, and there was also a wider sense that US had lost direction with its torture memos, to put it mildly. The reactions among international lawyers varied. Many scholars called for the responsibility of the United States, yet in my opinion, state responsibility failed to fully materialize. There were no real investigations into the US governmental policy and practice. Only a few soldiers were convicted. And I was left with the sense, what was this it? Is this all that state responsibility has to offer? But there were also international lawyers who felt that state responsibility had materialized, and this puzzled me. How could we interpret and understand state responsibility so differently? Other international lawyers reacted to the abuses by pointing in the direction of the newly established International Criminal Court as an alternative remedy. Suddenly, the international legal order had more to offer than state responsibility. there were qualitatively different responsibility regimes available, at least as a matter of principle. The manifestation of different responsibility thinking and different responsibility practices inspired me to look at their relationship and the broader field of international responsibility. In the recent years, there have been more and more literature on state responsibility. Much of this literature is exploring gaps in the law of state responsibility, such as shared responsibility or armed group responsibility. Alternatively, state responsibility is explored from the perspective of specific branches of international law, such as global security or human rights law. So there are critical traces of state responsibility here and there. But what I wanted to do with this book was to adopt a critical and a comprehensive way of looking at the general law of state responsibility. This, I think, is my main contribution to the state responsibility literature and discussion. The aim of my book is to reroute discussion so that the importance of state responsibility is not taken for granted just because textbooks present such a view, or because state responsibility features in international dispute settlement so frequently. I want to open my readers' eyes to the fact that there are shortcomings in the general law and that there is a whole forest of responsibility systems out there. A critical exercise is important as new rules of responsibility are being considered. What is more, there is also a slight possibility that an international conference could be convened tasked with turning the existing customary rules into an international convention on state responsibility. And this is something that Tarja Långström may be able to comment upon later. In my book, I look at the general rules of state responsibility from a functionality perspective, which means that the basic features of state responsibility rules should correspond to the surrounding world, to international social reality. I pay attention particularly at social control, collectivity, and the gradation of norms. I do not seek to raise specific questions about interpretation or application of the law. Rather, I focus on fundamental issues such as: is state responsibility law apt to deal with the broad variety of international legal obligations? Can the law of state responsibility affect the conduct of various actors? And are there worthwhile alternatives to state responsibility? My argument in the book is twofold. First, I argue that the normative value of state responsibility is higher than what may be called for if you look at its practical relevance in today's world. So, for example, while state responsibility is praised for being a general law of wrongs, I argue that state responsibility is not equally important in all fields of international law. Globalization has brought other actors alongside states and broadened the sphere of issues that are regulated globally. The deficiencies in the law itself have also left it sidetracked at times. The second part of my argument aims to show how alternative responsibility regimes have come to challenge state responsibility. The previous exclusive role of state responsibility has been called into question by the rise of liability thinking and international criminal law. These legal alternatives thrive on the idea to compensate for harmful but legal acts and to penalize especially horrific acts. The international community deals with oil pollution and nuclear damages in terms of liability, and genocide and crimes against humanity through international criminal law. Thus, they have diminished the role played by state responsibility. If we look at the existing problems and gaps in the law of state responsibility, we find shortcomings in all aspects of the law. It is increasingly difficult to define what constitutes an internationally wrongful act, the basis for responsibility. To define who the state is has become more complicated with legal pluralization and the blurring of the public and private, as well as defining what level of control is needed for attribution. We also see multiple and multi-level actors acting jointly, as well as fragmented states, rendering issues of responsibility complex. For example, how do we apportion responsibility to Poland and Romania for allowing torture to occur in secret CIA prisons on their territory in 2003 forward? And is the state still responsible for wrongs if it has outsourced, for example, the running of prisons for 50 years? What is considered governmental is increasingly up for discussion. Deciding when a breach has occurred is not always easy either. International obligations are more often than not vague, and the question of whether a breach has occurred is left for later settlement. This holds true, for example, in maritime delimitation and the realization of economic, social, and cultural rights. What is more, wrongfulness is adversarial in nature, leaving a moral overtone into interstate relations which may not be called for. For example, in international environmental law, it has often been considered more important to assist states in reaching their goals rather than claim that obligations have been breached. But tensions and shortcomings are found also in the content of state responsibility, that is, the remedies it offers. The functional diversity that state responsibility law embodies means that on the one hand, the rules seek to guarantee reparation for wrongful acts, but also to uphold overall legality, a more abstract function. So from the classic bilateral constellation, where one state seeks reparation from another state, state responsibility has evolved to protect norms that are fundamental to the international community as a whole. However, pursuing multiple aims under one legal framework is complicated. This necessarily then entails a streamlining of the law to protect common ground, leaving certain rules undeveloped. For example, there are no extra consequences upon the wrongdoer in cases of aggravated breaches. Similarly, the law restricts the use of collective countermeasures to respond to serious breaches. This in turn affects the capacity of the rules to prevent future breaches. And as I argue in my book, a functioning responsibility system should be capable of affecting both retrospective and prospective behavior. The rules of state responsibility are problematic also when it comes to implementation, much due to what is characteristic of international law more broadly, namely the lack of centralized enforcement methods. States decide for themselves whether they want to pursue responsibility and by what means. From this follows that whether they protect their nationals abroad who have suffered wrongs is discretionary. For instance, the United Kingdom has chosen not to exercise diplomatic protection to protect Guantanamo detainees who were residents in the country. Another detriment in the implementation of state responsibility is that states are highly unequal in terms of power. It appears highly unlikely that small states would pursue claims against major powers. One example often mentioned in this connection is the US invasion of Iraq in 2003, which was illegal. No state was likely to pursue the responsibility of the United States for this. Similarly, no small state would dare to claim that China is responsible for failing to notify the World Health Organization in accordance with the international health regulations for the COVID-19 pandemic. To sum up, when we talk about serious global problems or challenges, state responsibility has not played a crucial role. Environmental disasters are not, as a rule, treated as state responsibility matters. Neither has state responsibility been the preferred route in response to atrocity crimes. And now with the pandemic, we see that state responsibility, with its confrontational character, sits badly with global health issues as well, although it appears as a classic textbook example of state responsibility. So I argue that state responsibility is at the same time too confrontational and too lame. Having one responsibility system for all international wrongs does not correspond to the diversity of international law, its actors, and its beneficiaries. We need to accept that some wrongs are so horrific that reparation is not enough. We need punishment and strong signaling of values. But there are also situations where economically beneficial activities generate harms and remedy is needed. In these situations, no moral condemnation is necessary, but mere adequate compensation. Francisco García Amador, the first Special Rapporteur on State Responsibility of the International Law Commission, said in the 1950s that there is an infinite variety of responsibility situations and circumstances. I totally agree with his statement 70 years later, although the world looks completely different, which is why we should embrace the fragmentation of responsibility and take the diminished importance of state responsibility as a sign of development of the international legal order as a whole. Thank you.
Thank you, Katja, on overviewing the issues and also giving tangible examples of different problems and challenges that are entailed. So now, next I will yield the floor to Martti Koskenniemi. Put your microphone on.
Okay, do you hear me now?
Yes.
So thank you very much, Katja, for the introduction. Thank you for having written this book. This is, as I've said, I suppose already a number of times, this is an exceptionally erudite and intense work. Also, the subtitle of the book, Critical Appraisal, is right on spot. So this is truly a critical appraisal of state responsibility. And with that also of a central part of international law as we know it. And I would say I expect this book to be widely discussed because it raises in a new vocabulary concerns about the nature of international law and its functionality, its role in the international system that have arisen every now and then since late 19th century. I have to emphasize that although responsibility for lawyers tends to turn into a very technical, special type of set of provisions, it has a really important ideological impact on international law itself. It is kind of the other half of international law. We think that international law is law to the extent that there is a system of reacting to its breaches. So in the late 19th century, many people said that international law is not law because there are no courts and no police and no jails to punish those who breach international law. And the doctrine of state responsibility, the few cases that there are on state responsibility came about more or less as a response to that concern, to make international law seem something more than just a set of moral demands, to make it seem like a real legal order, so that if you breach that order, then there will be consequences. That's how we've learned to think about the domestic legal order as well. So this is about the consequences. And what the book says is that, well, mostly there are no consequences. There is a doctrine, but if you breach international law, it's very unlikely that anything will happen. Some journalists will write negatively, yes, of course. Some people will be hurt and will be making demands, but there is no system that then starts to operate in order to punish or demand or exact compensation from the one who has breached the norms. So that is what you're saying. So in the course of your introduction, you said that you point to some shortcomings in the state responsibility regime. Well, that's a really modest way of saying that you show that, well, apart from a doctrinal construction in the minds of academics, there really is very little in terms of real responsibility, real accountability when one breaches international law. Now, of course, you make an exception to that. There are specific treaty regimes, and you lay out in great detail, and I would say with great power, the two most important treaty regimes that have set up systems of compensation, of redress, of reaction when breaches take place. Namely, the group of treaties having to do with environmental harm and the treaty setting up the International Criminal Court. So in terms of breaching those treaties, if you pollute the ocean, for example, or if you carry hazardous wastes to the wrong places, or in some cases, if you participate in an atrocious war, then there might be consequences. But those consequences are not the result of the operation of a regime of state responsibility. They are the consequences of specific treaty regimes being in operation. Treaty regimes that are very active, which often have institutional bodies, a conference of the parties that review the operation of the treaty every now and then, that also take a position in regard to individual problems that have emerged. As you lay out quite clearly, however, those two types of treaty regimes, environmental liability and criminal responsibility, are in many ways very different from the state responsibility doctrine. The first part of the book lays out quite an exorbitant number of problems that the doctrine itself has. The problems, if one wants to generalize, rather result from the intuitive effort that most people quite understandably do to understand state responsibility through the domestic analogy. To imagine that state responsibility is like the domestic legal order, to the extent that if you breach domestic laws, then there will be consequences. They may be civil consequences, they may be compensation, liability, or they may be criminal consequences. You get fined or put in jail or whatever. So that world, the domestic world, is the world that frames our imagination also when we think about the international world. But as you point out, the international world is enormously different from the domestic one. So that the state responsibility doctrine, when you frame it in the domestic mindset and then you insert it in the international world, doesn't seem to do at all what the domestic legal system does at home. It doesn't deter, as you show. Nobody, at least no significant country, or I would say no country, no politician of a country is deterred from doing what they think is best for their country because their legal advisor will say, well, there is this doctrine of state responsibility that might catch you at the end. The political person turns then to the legal advisor and says, well, give me some examples of what might happen. And the legal advisor would say, well, actually, very little could happen because this doctrine is applied very, very rarely. Of course, again, one has to make an exception for those specific regimes that are there. Criminal liability, if what you're planning to do is to engage in atrocious activity where perhaps grave crimes against humanity are being committed. Fortunately, that's not what every politician contemplates very often. And an exception might be if you try to engage in polluting activities, provided that those polluting activities come under the treaties that deal with them. Even in such cases, however, as you point out, it's more a question of cooperation, of assistance, of technical assistance in particular, of discussing together with other treaty parties about the problems of implementation that you have unfortunately faced. That doesn't look like state responsibility. So if one moves away from those two regimes, criminal liability, the Hague Court, International Criminal Court on the one hand, and the specific liability regimes in the environmental law, very, very little is left. You give the standard examples. There is no fault usually in very many cases, especially fault in state operations or in the activities of state officials. Terrorism, for instance, often is undertaken by private individuals who use the territory and then attack another territory. So the state is not officially involved. The state officials wave their hands saying, we didn't know about that. And even if we knew, we had no means of preventing that sort of thing. So that, of course, was the situation in regard to industrial pollution earlier on. This was caused by private activities in private industries, private technologically advanced activities, and so on. So it's very hard to find fault in the state. Therefore, the doctrine often or usually doesn't talk about fault any longer. We think in terms of objective responsibility. However, state officials are not inclined to say that they could be, or that the state could be made accountable for something that it could not prevent, independently of whether it tried to prevent, independently of whether anyone in the state had any fault to begin with. As you point out also, the state responsibility regime imagines or pretends that all states are equal, like all individuals in the domestic order are more or less equal. But it's one thing to make a claim to the United States and another to make that claim to Luxembourg, or to make those claims in the northern, western, developed hemisphere, or in the southern world. And people don't make those claims. They don't make those claims because making those claims is kind of embarrassing and will anyway lead to nothing. And so state responsibility, although it's still ideologically important, because it's so hard to imagine a legal order that would not provide for consequences of breaking that order. Nevertheless, the imagination doesn't create the reality that it hopes to exist, which is ceased to exist in the domestic field. I could talk a long time about this. I realize that the time is very, very scarce. So I leave you with two things, two questions that the book really raises in regard to the future. So the book suggests, this is my first point, it suggests that it's possible to advance responsibility, accountability through creating specific treaty regimes to that effect. Treaty regimes that have treaty institutions that verify compliance with the treaty, and then at some point might develop an accountability regime as well. But it's really hard to imagine what those treaty regimes could be outside the environment and criminal law. And the treaty regimes always have the dark side that only some states become members of those treaties, and those states usually are the ones whose behavior occasions no problems with regard to the treaty. So that's my first set of questions. I see a way of development through treaty law. How efficient is this? The second thing is to think about international law differently. I said at the outset that most people move about with the domestic analogy in their minds, that in some ways the relations between states should be or is equivalent to the world between individuals. But maybe it's not like that. Maybe we use the word law only in a metaphoric cultural sense in the international world. It's something through which diplomats can come together. It is a common language, we say, with them. They can coordinate their state's actions better under these rules that, although have some appearance of the rules of domestic legislation, still are fundamentally different and rely on the willingness of those who apply those rules to actually act in accordance with the rules themselves. This could then be, I mean, if you're optimistic, if you're a Kantian liberal 90s type of cosmopolitan weirdo, then you might think that this creates a socializing process whereby the officials of states engage in technical and economic activities through these rules that seem to be mutually beneficent, and thereby slowly become socialized in a world of peacefulness and justice. I exaggerate this second point maybe a little, but I ask you whether there nevertheless could be something there. And I end there. Thank you.
I was just thanking Martti on those stimulating comments, and this understanding of law as a symbolic, metaphoric framework that works as a conditioning device as well is something that we should remember once in a while. So thank you for that, and now I will yield the floor to Tarja.
Thank you very much, Mika. And in the interest of that you actually can hear me, I leave the camera out, as it appears that my connection is not that good. I would like to thank Katja for the invitation, and of course Mika for the kind presentation, and of course the Finnish Institute of International Affairs for organizing the event. And Katja, I would like to congratulate you for the publication of this book. As has become clear by now, it is a very systematic, deep dive into not only state responsibility, but also liability regimes and individual criminal responsibility. I could well imagine that this becomes a textbook for law schools, in addition to being a refreshing and useful resource for anyone working in the field of international law. When I agreed to participate in this webinar, I knew that the book would present a critical appraisal of state responsibility. Learning about Martti's involvement and his participation in this webinar, I did not expect anything less. And I'm humbled to be able to offer comments on such a great book in this company. The book is indeed critical, but at the same time constructive in its critique, a critique which is of course justified. Why cannot international law have more teeth? As a government lawyer, I'm naturally inclined to be fond of state responsibility, as it is what makes my law, international law, seem like real law. It tells me and the whole international community that international obligations matter, that they need to be respected, and that there are consequences for breaches of obligations. To me, state responsibility has a strong system building effect and purpose. In my comments, I'm going to concentrate on state responsibility as a part of customary international law codified in the ILC articles on state responsibility that you already mentioned, and perhaps take up some promising developments in the area. The articles were drafted in such a way that turning them into a convention would seem to have been a logical step. Of course, the end result, 49 articles and commentaries thereto, was considered to be a delicate compromise, including both progressive development of international law and its codification. The International Law Commission gave only a modest recommendation to the General Assembly of the UN. Initial taking note of the articles with a subsequent consideration of a possible diplomatic conference with a view to concluding a convention. 20 years have passed and states have not managed to agree to put the articles to a diplomatic conference to negotiate a convention. Calls for such a move have intensified, and the Nordic countries, who speak with a common voice at the legal committee of the UN, are in a slightly difficult position among those states who continue to feel that a diplomatic conference on the basis of the articles would not be a good idea. The position is somewhat tricky because it means that we say no to codification of international law. As proponents of rules-based order, it would be only natural to be keen on arriving at a legally binding convention on state responsibility. We have, of course, valid arguments for saying why, even after 20 years after their adoption, the articles are in the strongest position as they are, just annexed to a General Assembly resolution. Last year, we said in the legal committee that although we agree that the multilateral convention is in general an ideal vehicle for guiding state action and creating legal certainty, there is also a risk that reopening the articles might jeopardize the delicate balance built into them. Furthermore, we underlined the significance of the articles as a framework within which the law has developed and continues to develop. Turning now more specifically to the book, I can only take up a couple of issues from this monumental work. First, perhaps the contention that the ILC articles might be doomed to irrelevance as non-state actors were left outside of their scope. On the government side, we have, of course, also noted that non-state actors have emerged into the international scene as right holders and sometimes as actors intentionally or unintentionally harming the interests of others. New regulation is called for. We should figure out, for instance, what rules govern the use of force by non-state actors and who is responsible for cyber attacks by non-state actors. However, for me, this is not much of the state responsibility law, but it is more a primary law issue. Being a set of secondary rules establishing the general conditions for the state to be considered responsible for wrongful actions or omissions and the legal consequences that flow therefrom, I would argue that the articles have stood the test of time and continue to be relevant and provide opportunities. Finally, I would like to discuss a bit the bilateralist communitarian tension or coexistence that the book dwells on, and that is at the heart of the delicate compromise built into the articles. Like Katja writes, I tend to agree that the many purposes of the state responsibility law include the protection of the bilateral obligations, the protection of international law generally, and then the safeguarding of norms of a higher rank that pertain to a process of constitutionalization of the international legal order. The articles contain provisions regarding erga omnes partes and erga omnes obligations. Article 48 gives right to the so-called non-injured state to invoke the responsibility of another state if the obligation breached is owed to a group of states and established for the protection of a collective interest of the group, or the obligation is breached, or the obligation breach is owed to the international community as a whole. All eyes are on the International Court of Justice, where the Gambia has filed an application against Myanmar under the Genocide Convention. The Gambia accuses Myanmar of engaging in a systematic policy of oppression and persecution against the Rohingya, a Muslim minority. This is not the first time that a non-injured state has sought to enforce obligations erga omnes partes at the court, but it is the first time such case is brought under the Genocide Convention. For the legal basis of the application, reference is made to Article 9, which is the dispute settlement clause of the Genocide Convention. The Gambia asserts that the prohibition of genocide is a norm of jus cogens, and that obligations owed under the convention are of erga omnes and erga omnes partes character. The court has notified states parties to the Genocide Convention about this application. And to my knowledge, Bangladesh, Canada, and the Netherlands have thus far known their intention to use their right to intervene in proceedings. This case provides the court with the opportunity to develop further its erga omnes jurisprudence and perhaps strengthen the customary law status of the relevant ILC articles. By indicating provisional measures, the court has determined that it has a prima facie jurisdiction, but of course, Myanmar will continue to contest the jurisdiction of the court at the further steps of the proceedings. Finally, I might mention that the Netherlands has made known its intention to pursue a similar route of responsibility against Syria on the basis of the Torture Convention. And we, of course, follow these developments with keen interest and see them perhaps as small steps towards responsibility. That would be all. Thank you very much.
thank you very much on that comment as well. Fascinating stuff. Perhaps it is now in the interest of this webinar that Katja would comment on these comments and reflect on the reflections. And there were also some questions. And at the same time, I would like for the audience to either put down your name there in the chat function of the Teams platform, or then write a question there directly. There's already one question from the audience. But Katja, perhaps you would like to reflect on the reflections.
I will reflect on the reflections, and I'll start with the reverse order. So I'll start with Tarja's comment here first. And Tarja is of course right. She has the government perspective, and I understand that state responsibility brings structure to her everyday work. And she is also right to point out that there have been developments where third states have taken cases to the International Court of Justice. I say in my book that there is no international claimant and that this actio popularis is very rare. So indeed, she is right to point out this development. At the same time, I would say about the Gambia-Myanmar that yes, it's good that the issue comes up and will be discussed, but will it eventually have any effect upon the protection of the Rohingya? It will take years and years, and we don't even see these Myanmar's reports. They are not even public to the court, what they have done to protect the Rohingyas. So already this indicates that we can't really judge and see how the effect of these claims. So making these Myanmar reports public would definitely give us, ability to answer a bit better. But I don't think that this case will provide a fast solution to the Rohingya crisis. Indeed, it will probably give us more to analyze after 6, 7, 8 years on genocide and international rulings. So in that sense, perhaps something more to analyze, but I don't think it will really amount to any great, judgments. And just saying this from past experiences with the court, I don't think Bosnia and Herzegovina was very pleased with the outcome of its 2007 judgment. So the court has been very cautious in finding genocide to begin with, and it has relied a lot on international criminal tribunals in this. And this is also a problem in the Gambia-Myanmar case. It has no material really to rely on. So the interaction between the individual criminal responsibility and state responsibility is lacking in this particular case. So it probably has to rely on UN materials only. So let's see whether that affects its findings and thinking. Then turning to Martti's questions about future possible regimes that could be. First, I would like to say something about the general context and the creation of the international criminal law system with the International Criminal Court and institutions. This was, of course, created in the positive atmosphere in 1998, when everything was possible in international law and you could do whatever you wanted, and there was no limit for what you could reach in terms of institutions and norms. So I think this is one thing to take into consideration. And today we start to talk more about even deglobalization or reglobalization even. So I think the problem for future regimes would be more, if we think about globalization, that it will take a new form perhaps with the rise of states that are not very fond of international institutions and international norms. So I think this is a main challenge, that in future we have probably the democratic Western-oriented states against a bunch of other states that are not inclined to do or create these regimes. So I think it will be more difficult. In my book, I mention two regimes or two conventions that have discussed responsibility, and one is cloning and also genetically modified organisms. So you can find perhaps potential in these not traditional international law issues, but in cloning it's interesting. You can see in the discussions that how it should be regulated, that either people say that it's helpful, it's economically beneficial, so it should be allowed, but there should be then a duty to compensate if harm arises. And on the other hand, many opponents say that it should be criminalized and it should be stopped. So we see these extreme tendencies, either to allow it or criminalize it, but nothing in between that state responsibility would contribute with. So I think here in these issues you could find potentially something that is created in due time. Artificial intelligence is very interesting and should be, I guess, regulated in the future. I don't know whether this would be something that the international community could unite. But I really think that the problem is now more the international atmosphere and the sort of division between states concerning institutions and international norms. Then law as a metaphor, the socializing process. I don't know if there was a concrete question there. I think one should be very cautious about socializing, and I want to pick up one example from my book, where the International Committee of the Red Cross investigated why there were so many breaches of the laws of war during the Balkan Wars, although everybody knew about the rules. So they really looked into the issue, and 4 out of 5, if I remember correctly, said that yes, they know the rules and they have been informed and they have accepted them. But at the end of the day, they said that it doesn't really matter if they know the rules, because now the situation has changed and they live in a totally different setting. So the socializing, I think, can only come to a certain point, help to a certain point, and then you lose it. Was there something else I was supposed to comment upon? Yeah, I think this was what I wanted to say at this point, and if Martti or Tarja has some more responses to what I just said, I'm happy to hear that as well.
Okay, thank you, Kat, on that, and let's wait a little while. Let's take some audience questions at this point. One question that I think is vital in here is when, Kati, you were referring to the relative silence of the small states, and a Thucydidean point that big do what they can and smaller do what they must. How do you measure that? Because that actually the small states, although they might remain silent, their understanding of international law is not that silent. There's other types of views and points on international law and the status of it, even though they might remain silent. So how about the temperature? How do you measure the temperature? In what cases and in what points can the silence be broken?
So the relative silence of small states. I think the case is, first of all, I think because international law is everywhere and we see it in so many different forms. And I think it's a shame that what non-international lawyers often pick up is these cases that pertain to the use of force. So all attention is going to use of force cases often and territorial integrity violations. So we see it with Ukraine and Iraq, and of course these are serious issues. But I think we should focus more on mundane issues and the everyday life. Of course, small states break the silence when they act through, for example, the European Union, the WTO, through institutional settings. So it's also a matter of how you perceive. Do you see the EU or the small states acting? So when they act together in this, I think they are comfortable in breaking the silence. But it's true that I think silence can also speak loudly, but I think I don't know how to make small states more comfortable in breaking the silence, but I think they do it in institutionalized settings and as part of bigger groupings. So
they are looking for shelter, and they can break the silence through the shelters, institutional shelters that they might find. The other question related to that had to do with urgency, that some issues are more urgent, and you already referred to artificial intelligence. So do those issues, kind of cyber-related issues or digital world domain-related issues, can those allow for breaking of the silence and for smaller states having a role? In here, I'm referring, for example, to Estonia and the manual that has been developed there. So does the urgency create opportunities?
Yes, it certainly does probably create opportunity. But it's not enough, of course, that there is just an urgent matter. Then perhaps there needs to be a violation or a case behind it that reaches the international headlines and forges the discussion. But of course, cyber-related issues, telecommunications are important to be regulated. But also the manual says, as far as I remember, that state responsibility is applicable. So in that sense, they don't see that there is a gap, although we know that in practical terms, things don't really look like that, because it's difficult to separate between the non-state actors and the state actors, and even to track where the attacks come from. So even though state responsibility applies in principle, it's not that easy then to make the claim at the end of the day. And also we remember here from the attack on the Finnish foreign ministry, which couldn't be solved really and brought forward because there could not be a finding on who was behind that attack. So I don't think urgent cyber-related cases will always bring forth the small states, but it's practical cases. And here, of course, we remember also the Georgia-Russia incident from 2008, which brought discussion on cyber. And in that sense, Georgia, as a small state, managed the case of Georgia managed to raise new issues to the agenda.
Okay, thank you. And perhaps now we can turn back to Martti and Tarja. How would you reflect back on Katja's comments?
Well, yes. I think Katja speaks here with the voice of real authority, having gone through all the imaginable cases of state responsibility in the last century or so, and that's obviously very impressive. So yeah, I agree with her completely in the sense that outside observers too often pay attention to really large crises and cases of use of force and developments that take the front page of the news, whereas in the background, rules are constantly being observed, created, they serve people's interests, and so on. This, of course, is a rather banal way of defending international law. The banality of it, I don't think, makes it any less true, though. It's just that it tends to be disappointing in view of the expectations that in the course of the 20th century, and maybe especially in the course of the 1990s, were created in regard to developing international law to a more institutionalized set of rules and responses to breaches of rules. So clearly, those expectations were wrongly placed. And now we should try to think beyond them, or think without being burdened down on the frustrating experiences of the various conflicts in which the rules, after all, did turn out to be disappointing. And in that sense, I still think that those two avenues need more thinking. So one is the treaty avenue, and okay, cloning, artificial intelligence, cyber, etc. I've participated in some of that activity, and I have to say that it's really hard to proceed down from the generalities of state responsibility to actual rules having to do with conduct, that technically advanced conduct that takes place in various states under the rubrics of, for instance, cloning or pandemics or cyber, maybe cyber in particular. So I think in order to advance there, I mean, this is a finished point to make, I'm sure, but confidence building is really needed. So it's only once the people around the table who want to proceed with the new regime have confidence that, well, you know, this is in the interests of all of us, and that we are going to, by and large, be good citizens in relationship to this regime, then something can be attained. So in this sense, I mean, domestically also, we've been accustomed to the sense that it's only in states in which a sense of basic trust and solidarity pertains between individuals, where the rule creation process is well organized and accountability exists. So, nothing that I've said critically suggests to me that one should give up the idea or the doctrines of state responsibility. They will be in the background. It's just that that overly ambitious activity at one point might maybe easily work against small steps. I detest myself saying those very conservative things, but I can't see, if one speaks in terms of how law might be used, how one could think differently. The cultural issue is a big thing. So the world of legal advisors and of the International Law Commission in Geneva, New York, those places, is very, very distant from the places in which decisions are made that then cause transboundary harm, both in the sense of use of force or dramatic action and less dramatic actions. States are constantly in contact with each other, and they step on each other's toes. And so the stepping on each other's toes obviously is an issue in which the cultural features of diplomacy can be to some extent influenced by more advanced rules and institutional processes. I really liked when you said it, that state responsibility is both too confrontational and too lame. That's an excellent description of the situation in view of the most ambitious expectations. But if then one goes down to examining the practices of diplomatic interaction and interaction with state officials and private officials working, or private actors working on behalf of states, then one realizes that rules are needed, and that a sense of compliance, a moral sense of necessity of complying, is a precondition for having all the good things that those practices suggests we should have. So I am a little bit disappointed that when one thinks about this, one kind of retreats back to the kinds of things that people were saying after the First World War. So in the 20s and 30s, when many of the international legal and other institutions that we now have were created, so it was this kind of a thinking where where rather low-level procedural activities were hoped to bring peoples together and prevent that the kind of thing that the First World War was would not repeat itself. And in some sense, that or those expectations already were frustrated very soon thereafter. So history will, I hope, give us surprises rather than repeat itself.
Thank you, Martti. Tarja, would you like to say something, some reflections on this ongoing discussion?
Well, thanks. There's a little I can add to that, but I of course subscribe to the contention that trust and confidence building is needed in the international negotiations, and perhaps the next year the negotiations will be easier in many fronts. So we're of course looking forward to establishing very good regimes for different things, and on this politician lawyer argument, I have not experienced that it would be difficult to speak law to power, but it's of course in Finland we are a law-abiding nation, and we agree that rules concern ourselves as well. So in that sense, any advice that one has given about the limits that the law presents in certain cases, it has not been difficult to get them through in the political department. We usually tend to trust our judgment. I'd say that. And perhaps finally, regarding the Gambia versus Myanmar, I of course agree what you said, Katja, but I would be thrilled to have a strong pronouncement from the court about the standing of a non-injured state regarding this issue, the ability of a state party to invoke state responsibility. So that I'd be thrilled to see something. Thank you very much.
Thank you. Katja, would you like to give some kind of an answer to that final point? What's going to result from that case? What would be the best possible outcome?
No, I would also be thrilled to have the court take a standing on the issue, and eventually also the whole genocide question. So no addition there. So perhaps, I mean, if there is some questions in the audience, Mika. I don't know if there are, but.
Well, I think I have went through most of the questions from the audience, and I think we are coming to a point where we need to wind down a bit. The discussion has been extremely stimulating so far. Well, actually, now we have a question there. Because we still have time to go through this. If states disappear, does it mean that its international responsibilities disappear? So
I'm guessing I'm answering this one. As I said, I've been looking with at the whole forest and not the details. So I don't remember by heart all the rules, but it's then the succeeding state that takes on the responsibility for what the state that disappeared state has done. But what I've been trying to do in my book is not go so much into these different rules, because I want to sort of paint with a large brush and look at the patterns rather than the specific rules.
All right, thank you very much, Katja. And it has been pleasant hour and 15 minutes. It's always good to talk with the people who understand the nexus between power politicization of law and then law conditioning power politics. This nexus is something that is very vital for the institute, and I'm happy that we have a nuanced understanding of this landscape being expressed in between in the pages of the book that Katja has now published. So we are very proud of you, Katja, and one day when we can physically meet, we will raise a toast to this achievement that you have made. So thank you, Katja. Thanks for the commentators. It has been extremely stimulating, as I have repeatedly said already. And thanks for the numerous audience as well, and the people who asked questions there. So thank you for this, and we will return to the theme, I'm sure. Thank you very much.